Assalamualaikum and hi everyone. Welcome back to our show where Ami talks about law, or Atal for short. Here we will discuss all the latest legal issues and unwrap and analyze all Malaysia's case law. In today's episode, our theme is tort, or to be more specific, on negligence. In today's case, we will be joining with a special guest. He is a final year student from the famous Ahmad Ibrahim Kuliah of Laws, or ICOL, in the International Islamic University of Malaysia. So everyone, let us all give a warm welcome to our friend, Mr. Yusof. Thank you, Ami, for inviting me to your show tonight. I'm very grateful for the chance to be here. Which is the previous court that the case has been trial to. Alright, Mr. Yusof, let us jump straight right in, shall we? So, we'll be reviewing the case of Pendaftar Hak Milik Negeri Selangor and others, and Muhammad Syaiful Lizam bin Muhammad Saleh and another appeal. So for everyone's knowledge, this case is an appeal case which takes after the trial in the High Court. So Mr. Yusof, can you summarize the facts of the case for us? No problem, Mami. I got you. So, before I explain the summary of the facts of the case, it is important for me to mention that there have been two appeals coming from the High Court. So, to make things easier for us to understand, I'll be referring the parties as what they have been referred to in the High Court. So, first of all, the plaintiff is the original owner of a piece of property located in Damansara in the district of Petaling. He claimed the first defendant has fraudulently channeled the said property to himself. He successfully transferred the property by using the documents of final title for the property, in which he obtained from the land office. By using forged documents, he was able to give a false impression that the plaintiff has sold the property to him. By using the same forged documents, the first defendant had managed to secure a loan from the second defendant, and the terms of the loan was arranged into a facility agreement in which the security of the facility agreement was a charge over the property itself. The loan was allocated in a form of a banker's check. However, the first defendant failed to pay back the loan, so the second defendant began the foreclosure process and obtained an order for sale of the property. The plaintiff alleged that he soon realized he had been defrauded after he discovered that the second defendant intended to sell off the property through an open auction. So, understandingly, the plaintiff commenced proceedings in the High Court against all the defendants to assert his rights on the property. And at the end of the full trial, the trial judge held allowing the plaintiff claims against the first defendant and declared the first defendant's title interest was defeasible. However, the trial judge dismissed the plaintiff claims against the second defendant and ordered the second defendant to proceed with the auction of the property. Aggrieved, the plaintiff and also the land office both appealed to the Court of Appeal. Interestingly, both courts agreed that the first defendant was a fraudster. However, that is not the main issue now. Thank you, Mr. Yusof, for that brief summary on the case. So now that we have understand what really happened in the case, you told us that that is not the main issue. So, from your perspective, what is the main issue? What is the legal issue that you found in this case? So, the legal issues that I found in this case regarding the issue of tort or negligence is two. First, whether there was negligence on the part of the land office, and second, was there negligence on the part of the second defendant? So now that Mr. Yusof has explained to us what are the background of the case and also give us the legal issues that comes with it, now moving forward, Mr. Yusof, I would like to ask, what are the claims or the arguments provided by both parties, the plaintiff and the defendant? Sure, Ami. So regarding the first legal issue, the arguments from the parties can be further divided into three. And the first argument is coming from the land office. The land office is represented by the State Legal Advisor, or ALA for short, and they had alleged that the learned trial judge has erred in finding the land office negligent and that they had conspired with the first defendant. Furthermore, they argued that the plaintiff failed to specify the act of negligence of the land office. and further submitted that a standard operation procedure has been in place and practiced by the Land Office when dealing with the qualified final title. Therefore, they contested that there was any negligence from their part, while also stating that they are protected under Section 22 of the National Land Code, that no officer under this act that has been appointed can be held liable for any act or omission done in good faith. The ALA further claimed that it was the plaintiff and the second defendant who were negligent. It was the plaintiff who failed to update his address with the Land Office. The second defendant was negligent as they knew the plaintiff was living at the same address while knowing that he has an address in Subanjaya and yet did not take any due diligence before proceeding with the loan with the first defendant. Moving forward is the plaintiff argument. The plaintiff is represented by his own counsel and they had submitted that the learned trial judge was correct in regarding the issue whether the Land Office was negligent. They claimed that there was no compliance from the Land Office with the procedure provided by the National Land Code under Section 90 and 192, where it requires the presence of the proprietor in order to receive a form and the preparation of the final title document itself. Moreover, the Land Office has been negligent, they claim, when the false identity card given by the first defendant to the Land Office, and yet they did not recognize that the plaintiff as a Muslim. Had the Land Office been careful, the forgery could have been discovered far earlier. The plaintiff argued that the Land Office failed to explain why the procedure under the National Land Code was not followed and how the document from the said property went missing. And for our final argument is from the second defendant, and they had also agreed with the plaintiff that the learned trial judge was correct in regarding the issue whether the Land Office was negligent. And to further strengthen their argument, they provided witnesses from the Land Office itself, in which these witnesses agreed that there was negligence on the part of the Land Office in handling the matter, as the Land Office did not have any record as to whom the final title of the said property was released. Along with another witness, they admitted that there was a deficiency in the record-keeping system and there was some shortcoming on their part. So, Mr. Yusuf, now that you have given us an extensive look to the claims and arguments that the both parties has provided, the appellant and the respondent, can you give us what is the judgment? What is the decision that the Court of Appeal has provided in this case? So, now that we have arrived to the decision of the court of appeal dismisses the Land Office appeal while allowing the plaintiff appeal, and so the rights of the plaintiff towards the property has been asserted, and the Land Office is held liable to pay the second defendant special damages in the sum of 1,955,000 ringgit Malaysia. The court also ordered the second defendant and also the Land Office to bear the legal costs of the plaintiff. Thank you, Mr. Yusuf, for providing us with the court's decision. Now, I would like to ask you, are you able to provide us with the ratio behind the judgment or the reason behind the court's decision? Sure thing, Ami. So, the ratio can be divided into two parts as to answer the two main issues. The first issue is the court referred to the case of pendaftar hak milik Pejabat Pendaftaran Wilayah Persekutuan Kuala Lumpur and another and Poh Yang Hong. So by referring to this case, the judge concluded that the land administrator can't depend on the provisions given under Section 22 of the National Land Code, as they cannot explain in regards to the documents lost pertaining to that said property and how did the final title property came into the hand of the first defendant. So secondly, the court referred to the Canadian case of Esser and Brown, in which the court held that the omission of the second defendant is not foreseeable, that it may cause the plaintiff to be deprived of his rights. There was no proximity between the second defendant and the plaintiff, therefore they do not owe a duty of care towards the plaintiff nor the Land Office. So those are the ratio behind the judgment. I see now. So now that we are at the end of our segment, I would like to ask you one final question, which is, what is the significant impact of this case towards the law in general? Oh, the significance to this case? Well, I think there are many, but to make it short, in my humble opinion, this case is very significant to the law of tort within Malaysia, as it helps highlight on the issue of negligence that has been committed by officials working under the state government and whether they can be held liable. So, in this case, the Land Office sought the protection under Section 22 of the National Land Code. Therefore, they cannot be held liable for their acts or omissions. However, the plaintiff are able to prove that the Land Office has breached their standard duty of care and therefore created a causal link, which the court then reaffirms. So for my second point is, the case is significant because it further interprets the duty of a solicitor towards their client and whether their acts or omission are held liable if the third party suffers damages. So in this case, the court explained that the damages suffered by the plaintiff was unforeseeable and further explained that there was no close proximity. Therefore, they hold no duty of care. And to analyze it further, we compare it with some cases that are similar in facts and ratio. And we refer to the case of Sun Pui Yong or Sun Pui Yong and Westport Properties Sedian Berhad and others in 2015. So the facts are, the plaintiff was the original owner of a property and had been defrauded by the second defendant also. So, but the difference are that the second defendant falsified its power of attorney instead of forgery of the documents. So the court held that the plaintiff is allowed to claim damages. However, it is not able to claim the said property due to the falsified documents. So we can see the difference between the judgment of these cases. And next, we refer to the case of Pendaftar Hak Milik Pejabat Pendaftaran Wilayah Persekutuan Kuala Lumpur and another, and Poh Yang Hong in 2015. So the facts are, the respondent had entered into a negotiation for a piece of property from the appellant and had visited the said property only to be ousted by a person named Muhammad who claimed to be the owner. The respondent's solicitors immediately carried out 2 official searches on the land and found out that the land had 2 titles sharing the same lot number. So the respondents sued the appellants in the High Court for damages for negligence for failing to ensure that the particulars of the register at the Kuala Lumpur Land Registry were accurate. The appellant denied any duty of care and stated under Section 22 they were absolved from any negligence charges. So we can see that it is similar. The Land Registry also used the same section to absolve them from any charges. So the court dismisses the appeal and held that the Section 22 of the National Land Code had no application in the instant case, as the existence of 2 copies of the same title showed the appellant has not worked in good faith. So yeah, that's all. So that's from me. Thank you, Mr. Yusof, for coming here. So I think that's all the time that we have. Until next time, tune in to Atal, Ame Talks About Law. This is Ame signing off.